Now, just to exercise some expectation management, you should know that I've just sent Dan a text going, notwithstanding I barely understand this, I'm still going to try and do a vid. But this is on the back of Dan's video about Kemi Badenoch and Nigel Farage and the sort of, accusations and counter-accusations about whether that clicker was accurate or not. But it's got parliamentary privilege and the Bill of Rights in it, and a bit of Article 10, freedom of expression. So I know you like all this sort of stuff. So what's the starting position? Well, the starting position is Article 9 of the Bill of Rights, 1689, which says, and I love the spelling on this, that the freedom of speech and debates or proceedings in Parliament, with a Y, ought not to be impeached or questioned in any court or place out of Parliament. And that's what we call parliamentary privilege. Now, just to say, the Bill of Rights, it's unusual because it's an act of Parliament, it is a statute, but it is actually called the Bill of Rights. That's because statutes generally have titles anyway. So the Theft Act is just the Theft Act. We don't quite do what the American things does, where they give them big sort of flowery titles. I mean, our acts are always like really boring, like the law reform brackets, miscellaneous provisions, close brackets, and all that sort of nonsense. But yeah, that is the law as it stands. And what that says is that within Parliament, parliamentarians, whether they be MPs in the House of Commons or Lords in the House of Lords, they can do or say what they want, or indeed take any action within Parliament. And no civil or indeed criminal liability can generally attach. I mean, this gets very interesting into cases of, if somebody was taking bribes and things. And we will come on to that, because that is very relevant about what counts as parliamentary proceedings. But say, for instance, where it comes to contempt of court. Contempt of court, as we know, can be a criminal offence. So what if somebody breaches a super injunction? Well, that's what happened with Ryan Giggs, the footballer. He was being anonymised in some privacy case. But somebody in Parliament said, there is an injunction, and the person we're all speculating about and chanting on the terraces is Ryan Giggs. And, the MP could do that. And there was nothing that the court could do about it. They couldn't bring contempt proceedings. There's also the argument as to whether they could be disciplined within the House. But remember, it actually says any place out of Parliament. So Parliament can indeed impose its own regulations and indeed punishments, and we'll come on to that. But yeah, so somebody was able to breach an injunction and there was no comeback. And then, of course, it's a defence to contempt of court and defamation proceedings that you're just doing fair and accurate recordings of what happened in Parliament. So that meant everybody could do it. Similarly, there was another case where a bunch of people were being investigated for historic something abuse allegations. And the police had chosen not to name them at this stage because it was just investigations. And also they'd taken a bit of a hit where they'd named a pop star in some investigations, and then it all went nowhere. And they had to pay out. They got sued and they had to pay out. So they were being a bit cautious and not naming anybody. But an MP, Mr. Hemming, he actually did name these people in Parliament. Now, he got some criticism for that because it later transpired that they were demonstrably innocent. The police did their investigations and said these are all false accusations, and indeed the person who'd made the accusations was themselves later convicted. But there was no comeback. Now, what some people have said is that maybe the Speaker of the House should have powers to penalise MPs for doing things like that, or for breaching the rules, breaching contempt. Some people have suggested that the procedure should be, I am thinking of breaching an injunction, or I am thinking of naming these people. I will come to you for some guidance, and if the Speaker says, yeah, that's fine, it's fine. If the Speaker says no, well, it's up to you. If you still go ahead with it, then you could be disciplined, procedurally within the House. But of course, the mere fact that parliamentary privilege exists, all that does is protect people from being sued or being prosecuted. It doesn't stop people commenting about what goes on in Parliament, because then you've got your Article 10 rights. Now, this is Article 10 of the European Convention of Human Rights, as opposed to Article 9 of the Bill of Rights, because that's another thing. The Bill of Rights has articles rather than sections or clauses, just to be equally confusing. So journalists, or indeed anybody, can comment about what people get up to in Parliament, about politicians. But what if a politician wants to sue on the back of that? They say, well, you have defamed me. Well, you get into an interesting thing there, because the defendant, say it's a newspaper, they can say, well, this isn't fair because you're suing us for libel. We are commenting about what you got up to in Parliament, and we are not allowed to comment about anything you did in Parliament because you have the protection. So we can't say things like, well, you lied about this, or we need to examine the record, or we need to examine who you were meeting in Parliament, especially when you get all the accusations of backhanders and things like that, or meetings. We suggest that you were taking backhanders from people, or you were doing sort of cash for questions or something like that. We need to be able to investigate what you did in Parliament. And the Bill of Rights and Parliamentary privilege says we can't do that. So it used to be, Section 13 of the Defamation Act, 2013, said you can waive parliamentary privilege. So if you are an MP and you want to sue somebody for libel, you can say, okay, I'm suing you for libel. Now I accept the only way you can run your defence is to investigate what I got up to in Parliament. So I waive all my usual protections about that. And you can challenge, because that's all impeach or question, it says impeach or questioned. So you can question what I got up to in Parliament, and I can't rely on parliamentary privilege. And that's what happened in the Al-Fayed and Hamilton and Al-Fayed case. Remember where they were saying you were taking cash for questions? And Hamilton waived parliamentary privilege, so he could argue and say, no, what I was doing was perfectly proper, it was within the rules, etc., etc., and all that sort of thing. Another George Carman classic there. He was on the make and on the take. George Carman, despite the fact that he was a notorious party animal, and they literally would have to find him in whichever drinking establishment he'd spent the night in and literally sort of prop him up and wheel him into court on one of those trolleys that we carry all the boxes of papers on. They could just throw him in there and say, right, get on with it. And he was very good at thinking on his feet. And like I say, and that did not end well for the Hamiltons. They lost. And that actually got another interesting case, which was Hamilton had been sponsored effectively as an early form of crowdfunding. So, of course, he lost. Loser pays, winner's costs. Well, he said, I haven't got any money. I personally am bankrupt, which stopped him being an MP after that, because you can't be an MP if you're bankrupt. But they said, well, we'll just go after the people who funded this then. Because there's a thing, Section 51 orders allow you to make a costs order against any particular person. And quite often they will do that if somebody has been funding litigation, especially if they've been funding it through self-interest of their own, effectively sponsoring somebody to bring a court claim, because actually that's a collateral benefit to you. But what they actually said in that case is people who just chip in because they support a cause, and they don't actually have a personal interest in the outcome, they're just supporting somebody they like, or a cause they like, then you can't go after them. So that's why, generally speaking, crowdfunding is pretty safe. You can sponsor somebody to bring a case, and even if they lose, you won't be on the hook. But in that particular case, he waived privilege, didn't go very well for him. But that's happened. However, Section 13, the ability to waive privilege, has now gone. Because what they said is, well, it's not very fair, because generally speaking, MPs, people in Parliament have all this protection through parliamentary privilege. So is it right that they can just abandon it when it's convenient for them? Because somebody can malign you, an MP could defame you in Parliament, you can't do anything about it. But if, they say, well, an MP says, you've defamed me, they can suddenly go, oh, well, forget all about parliamentary privilege, I should be entitled to sue you. And people say, well, that's not very fair, because it's, it's very one-sided. So they've abolished that now in the Deregulation Act. They just said Section 13. It came under the section of no longer a practical matter at law. Because, people had wondered about this before. I mean, it's not a very common thing that parliamentary privilege comes up, and that's why we don't have many cases on it. But there is one case, and I'll link to it in the description, because they go into some detail there, and I'll leave it to you if you can make head and a tail of it. I mean, you can see how difficult this is, that one of the issues in the case was people had been going backwards and forward with claim, defence, reply to defence, reply to defence, and it wasn't until quite a late stage somebody said, oh, hang on a minute, all the parliamentary privilege thing kicks in. Because in this particular case, so Mr. Yeo, an MP, he'd been accused of effectively taking bribes. And he sued for defamation, and he wanted to waive privilege because he said, look, I have been cleared. A parliamentary committee has cleared me. And they said, well, that's, that's a thing in Parliament. We can't refer to it. And now that that's gone, you can't waive privilege to say, the newspapers said, well, we can't defend on the back of, because we would challenge that and say this is all rubbish. So we're saying you shouldn't be allowed to put in that you have been cleared anyway, because we cannot challenge that. And actually, in that particular case, the judge said, yeah, all that stuff's gone. You can't waive parliamentary privilege. Therefore, that pretty much stymies it. I mean, the case did go ahead because they said there's lots of other things that you don't need to get on parliamentary privilege because a lot of the behaviour taking place outside of Parliament. They've done surreptitious recordings and things like that, And they said, you can actually defend it just by sort of basically going, here's a load of tape recordings of him, and it does seem that he is effectively, being willing to trade access to Parliament and favours in exchange for a material benefit to himself. But that's where it stands now. So in that particular, like I say now, MPs still have the ability to say what they want in Parliament, but you can pretty much say what you want about an MP in regards to their conduct in Parliament, and they would have a difficult time suing you if the only way you could defend the case was to refer to what they'd done in Parliament. So if you were saying, they are having secret meetings with people, or are they having meetings with people and it's all very dubious, or they are asking questions in exchange for cash, because the asking questions is a proceeding in Parliament, we wouldn't be able to defend ourselves because of, what the Bill of Rights says, because that would be questioning what went on in Parliament. And now MPs are no longer permitted to waive that. So there you go. So a victory for free speech, arguably. Like I say, this doesn't crop up a lot, but it'd be interesting. I don't think this Badenoch and Farage thing's going anywhere because, even though it's an allegation of fraud, which is, of course, an allegation of a criminal offence, so, that usually is deemed to sort of say, well, you've got to prove serious harm, but if you are accused of an offence that can attract a sentence of 12 months or more, we'll assume that that would cause you serious harm. I don't think it would go anywhere, but if it does, it'll be really interesting, because it'll bring up all issues of parliamentary privilege and things like that. I'll get another video out of the back of it, and hopefully somebody smarter than me will be able to comment on this, and I'll be able to sort of hopefully plagiarise what they say. But like I say, I'll link to the judgment, and you'll see there that even the judiciary and the lawyers in the case, and these are very smart people, they were struggling with all this. So that's my excuse. But anyway, as always, hope you found that vaguely interesting, vaguely useful, vaguely accurate. And yeah, I'll see you next time. And I've just realised I've just left Lord Loverduck and Cappy Barrister over there. They're just chilling. It's Christmas. Oh, and sit here. Shall I do another Kubrick stare? That seems to do that one. Like I say, I'll probably get Dan to do the thumbnails on these, because when Dan does the thumbnails, they do really well. And when I do the thumbnails, like 4 people watch them.